Good afternoon, everyone. Thank you very much for joining us today. My name is Connor Tucker. I'm chair of the Beverly Hills Bar Association's Appellate Law section. I'm very excited about today's presentation. When I was in law school, a leading appellate advocate came to talk to us about what appellate law was. And he said, I'm an appellate attorney, and it's like I show up on a battlefield after the battle's over and I shoot the wounded. And I learned after that that he was mainly a appellee's lawyer, a respondent's lawyer, and that makes sense. But today is all about how you give your wounded soldiers the best chance of fighting back when a big mean appellate attorney shows up to after the fact. So I'm delighted to introduce our panel for preserving error for appellate review today. We have Gerald Serlin and Aaron Kelly. Gerald M. Serlin is the founding attorney of his firm and a California State Bar certified specialist in appellate law. He clerked for acting presiding justice Robert E. Rickles and Associate Justice John H. Hughes of the California Court of Appeal and is admitted to practice before the U.S. Supreme Court, the Ninth and Tenth Circuits, and the U.S. District Courts of California. He is a member of the Los Angeles County and San Fernando Valley Bar Associations and the Consumer Attorneys Association of Los Angeles. Over the course of his career, Gerald has received numerous honors in appellate law, including recognition from Super Lawyers, Best Lawyers in America, and the Daily Journal's Clay Award for Extraordinary Achievement in Appellate Practice. Aaron Kelly is an attorney at Benedin and Serlin LLP, where she focuses on appellate matters and employment litigation. She's been recognized by Super Lawyers as a rising star. And so with that, I'll kick it over to you.
Well, thank you very much.
Thanks, Connor.
This afternoon, Aaron and I will be addressing preserving errors for appellate review. If a trial judge enters an erroneous adverse ruling that prejudicially affects your client, unless you take immediate action to preserve the error, you will lose your right to challenge the ruling on appeal. This is so because, for the most part, appellate courts will not consider issues raised for the first time on appeal. As our Supreme Court has long recognized, an appellate court will ordinarily not consider procedural defects or erroneous rulings in connection with relief sought or defenses asserted where an objection could have been but was not presented to the lower court by some appropriate method. So, in short, counsel's failure to immediately act will be treated as a waiver, a forfeiture, or an estoppel. This preservation of issue requirement is not simply a meaningless technical barrier to review. Rather, the purpose of the general doctrine of forfeiture is to encourage parties to bring errors to the attention of the trial court so that they may be corrected or avoided, and so that a fair trial can be had. And think about it, if the requirement were otherwise, the party against whom the adverse ruling was rendered in most cases would simply remain silent until it were too late to fix the error, with the result that the judgments would be subject to increased challenges on appeal. So the preservation of issue requirement prevents parties from playing the game of gotcha.
Here's a roadmap for the next hour. We're first going to discuss how to properly preserve error. Then we'll talk about a few common contexts in which error may arise. And then we'll identify a few exceptions to the general rule that if you don't raise it in the court below, it's forfeited. We'll also reserve a few minutes at the end to address any questions you all may have. But before we fully dive in, we should be clear about the legal doctrines that are at play when it comes to the preservation of error. Litigants and even courts often use the terms waiver and forfeiture interchangeably, but the doctrines are actually in fact distinct. A waiver is the intentional relinquishment of a known right. So for an example, appearing at a motion hearing waives an objection to the adequacy of notice of the hearing, or expressly conceding liability during trial waives an appeal from a finding of liability. Whether a litigant has properly preserved the error for appeal, though, that implicates the forfeiture doctrine. And forfeiture is the failure to make a timely assertion of a right, such as failing to timely object to the admission or exclusion of evidence, or omitting an argument or issue from a brief. So with that squared away, we can dive in. We identify four, oops, went ahead too far. We identify four basic procedural requirements to preserve error for appeal. And these may seem obvious to you, but we do find it's helpful to have this checklist to ensure that error is properly preserved. We'll go into each of these further in detail momentarily, but in short, these include clearly objecting and including all bases for your objection, making a timely objection, procuring an express ruling from the court, and making a record of your objection. So clearly objecting and including all bases for your objection. Appellate courts will consider objections only if they're raised sufficiently so that the trial court had notice of the potential error. And this requires trial counsel to explicitly request relief from the trial court in connection with their objection. An example is in the Fontana indoor swap meet case cited in this slide. There, the appellant argued that he was denied a fair trial because he claimed another party had made inappropriate faces and engaged in other inappropriate behavior during trial. And at one point, his counsel even requested a break and informed the trial court he noticed that the other party was distracting the witness and acting inappropriately. And this is the key part, the attorney did not ask the trial court to take any action in response to his observations. So as a result, the Court of Appeal did not consider the appellant's contention that he was denied a fair trial on this basis because his counsel made no specific request of the trial court to exercise control or to stop the inappropriate behavior. This is obviously a cautionary tale about why it's important to both state your objection and request the trial court take action in response to your objection. Now, similarly, appellate courts apply a general rule against entertaining arguments on appeal that were not adequately developed in the trial court. Mentioning error in passing, for instance, it's not sufficient to preserve it for appeal. And an argument may be forfeited if it's buried in the middle of a brief section addressing other issues. In preparing your briefs, it's very important to set forth each distinct issue, preferably under its own heading or subheading, so the record's clear that the trial court was on notice of the argument. And perhaps most obviously, you must provide a specific ground for your objection. A general objection like I object or an objection on the incorrect legal basis will not preserve the error on appeal. And it's practically like making no objection at all.
And again, this may seem obvious, but your objection has to be timely. You may forfeit your objection if it is not asserted at the earliest opportunity. Thus, for example, during trial, an evidentiary objection must be raised after a question directed to a witness is asked, or if that's not possible, addressed by a motion to strike. But you also have to be careful on the other side. A party cannot wait for the witness to answer, speculate that they're going to get a favorable answer, and then move to strike after the attorney discovers that the answer is not favorable. So these are sort of typical objections or typical situations where an objection has been found to be untimely. In one case, a hearsay objection to an expert's opinion was untimely where it was raised as a part of a later motion for mistrial. An objection to expert testimony was untimely where it was made after the expert had finished testifying. Or similarly, the plaintiff forfeited objection to an admittedly improper testimony where the plaintiff did not move to strike the testimony until after the witness was cross-examined. Please note that an objection raised at a prior proceeding is also not sufficient. For example, our Supreme Court required that objection to the introduction of photographs in one particular case be raised at a second trial, even though the same judge had overruled an objection to the same photographs at the first trial. As the Supreme Court went on to explain, not only might a party elect different trial tactics at a second trial, but the trial court, being more fully informed, must be given the opportunity to reconsider the prior ruling. A party may not acquiesce in the admission of possibly excludable evidence and then claim on appeal that the ruling was made in a prior proceeding and that rendered objection unnecessary. Finally, a tentative pretrial evidentiary ruling does not preserve the issue for appeal if the appellant could have, but did not, renew the objection and press for a final ruling in the changed context of the trial evidence itself. This rule applies, for example, where a court rules on an in limine motion that evidence is admissible. The safer practice is to renew the objection at trial to preclude a forfeiture claim. And the converse is also true. If a motion in limine is denied, renewal is the better practice where changed circumstances or substantially different evidence is offered. The motion in limine ruling was tentative or conditional. The evidence was not specifically identified in the motion in limine, or there is a changed factual context between the pretrial motion and the trial. This may not come as a giant surprise either. You need to procure an express ruling. Absent a ruling, there's no error to appeal. There's nothing left. If the trial court neither expressly rules nor reserves its ruling, it is the responsibility of the objecting party to make some effort to have the court actually rule, or the party may be deemed to have forfeited or abandoned the objection as it was not made in the first place. So when a trial court fails to rule on your objection, the objecting party must do something to precipitate an actual ruling or be deemed to have waived or abandoned the issue. And for those of you old enough to remember, in days gone by, trial judges used to regularly fail to rule on evidentiary objections in summary judgment motions. As a result, those objections were deemed waived. And it was not until Reed versus Google changed the law so that if a trial court does not rule on evidentiary objections in the summary judgment context, the appellate court will deem the objections to have been overruled and the objection and treat the objection as having been preserved for appellate review. So that's the new rule, but the old rule was sudden death for practitioners if they failed to procure evidentiary rulings from the trial court.
And obtaining an express ruling is really important, having read several trial transcripts. I know in the flurry of trial that sometimes you can get to the point where you understand where the judge is going, but the record does not actually reflect the judge ordering whether to admit or exclude evidence. And so getting that express ruling and confirming it with the court will ensure that you've properly preserved for appeal. And, relatedly, the rule of thumb in making a record is that if it is not in the record, it did not happen. A couple of examples: an appellant cannot challenge the sufficiency of evidence to support the judgment on appeal absent a record of oral proceedings in the court below. And likewise, an appellate court will not reverse a discretionary ruling by the trial court when there's no record of the underlying proceedings or the trial court's reasoning. An example here comes from a case called Bullock versus Philip Morris, and that's cited in an article included in your materials. There, the Court of Appeal held that the appellant could not claim the trial court committed error in failing to give a jury instruction because the record was insufficient to show the trial court refused to give the instruction. The court's conference on jury instructions was held in the judge's chambers, and it wasn't reported by the court reporter. So to make matters worse, the appellate record did not contain a final set of written jury instructions showing which instructions were given and which were refused by the court. So as a result, the appellate court presumed the appellant either withdrew the requested objection or had omitted it from the final requested jury instructions. And it's because of situations like this that you should always retain a court reporter to transcribe important oral proceedings. You should always request the court reporter to be present at sidebars or conferences in judgment in the judge's chambers in particular. And if for whatever reason the sidebar or the chamber's discussions go unreported, you need to put the substance and the results of the discussions on the record later when the court reporter is present. This is key. Now, similarly, if a deposition is used at trial, it must be reported. And the best practice is to have the court reporter at trial transcribe the deposition testimony that's in the trial record. But I know court reporters at trial are often loath to do that. So at the very least, the record should reflect the pages and lines of the testimony that were either read or played, and the deposition transcript needs to be lodged with the trial court. You really don't want to end up with a trial attorney I spoke with recently who found himself in quite a predicament. He had just won his trial, was celebrating his victory when his opponent, of course, had appealed the judgment. And this trial attorney was in the process of preparing his respondent's designation of the record on appeal. This is a situation where the respondent, the person who won in the court below, has an opportunity to identify testimony or other documents that they want to add to the appellate record when they eventually prepare their respondent's brief. And it was only at that time that this trial attorney realized that the deposition testimony that was played by video at trial was not transcribed by a court reporter. He had verbally stipulated with the other side to what testimony would be played for the jury. There was no written record of which parts of the deposition transcripts were either read or played. And of course, the court reporter did not transcribe those proceedings. So, after everything he went through to get that victory, he was left with a difficult situation, to say the least. Thankfully, the California rules of court do allow two avenues to create an appellate record where the proceedings were not transcribed by a court reporter. If the parties are able to agree to the substance of the testimony or another oral proceeding, they can jointly submit something called an agreed statement. And an agreed statement, the parties jointly prepare a description of the testimony or the oral proceedings and submit that, which will proceed to the Court of Appeal for the appellate record. If the parties are unable to agree to an agreed statement, though, the party seeking to make an appellate record may request what's called a settled statement. And a settled statement is a summary of the trial court proceedings that's approved by the trial court. So each party usually submits their own proposed settled statement, and after reviewing the parties' proposals, the trial court eventually certifies a final settled statement of the trial court proceedings. And the Court of Appeal does accept both an agreed and settled statement in lieu of a reporter's transcript of the oral proceedings, but it's much preferred to have the actual testimony in the record. So you would be wise to save yourself the agony that my friend was going through and have any important proceedings transcribed by a court reporter.
It's also a lot less expensive to get a court reporter than to try to start filing these, requests for settled statements, because then you have to go back, aggregate the materials for the separate settled statement, go before a judge who then resolves it. And it's an acrimonious procedure, and it typically is not very satisfying because undoubtedly you, as the proponent of the information, going to remember things which opposing counsel doesn't recall, and a busy trial judge certainly doesn't recall. So
certainly, and I will say, I know as a former trial attorney that the cost of court reporter is astronomical these days, but I can assure you the cost of the attorney's fees you will expend in preparing a settled statement is going to be much higher.
Okay, we're now going to turn our attention to the specific contexts within which error may arise. This is not a complete list, but this was just some of the more major areas. So we will be looking at review of state court arbitration awards, evidentiary issues, motions in limine, jury instructions, special verdicts, statements of decision, and post-trial motions. So just to get things moving, in the context of state court arbitration awards, review of state court arbitration awards is restricted to the grounds set forth in Code of Civil Procedure section 1286.2. In general, to preserve an appellate challenge on the statutory bases, i.e., to avoid a claim of forfeiture, the losing party must raise the legal issues before both the arbitrator and before the trial judge by way of a petition to correct or vacate the award. And it's not hard to find instances where a waiver or a forfeiture has been found at both levels. So in the context of raising issues before the arbitrator, in, for example, a case by the name of Marino versus Writers Guild, a party's claim that it was fundamentally unfair to keep the arbitrator's identities confidential was waived by failing to protest the procedure before the arbitrators were selected and before they began performing their tasks. Or in another matter by the name of Blatt versus Farley, an investor filed a demand for arbitration against his investment advisor. He sought $80,000 plus interest, attorney's fees, punitive damages, and the arbitrator awarded the investor just north of $200,000. The Court of Appeal rejected the appellate challenge brought by the investment advisor because he failed to complain to the arbitrators that consideration of damages exceeding the $80,000 that was set forth in demand was improper or had been amended. So that issue was then perceived as being treated as being waived on appeal, and the judgment for the investor was affirmed. Likewise, by failing to raise matters before the trial court, there will often be a waiver or a forfeiture found. In a certain case by the name of Louise Gardens versus Truck Insurance, the Court of Appeal found that the failure to make a motion to vacate on the basis that the arbitrator should have been disqualified or should have disqualified himself waived the argument on appeal. Likewise, in a Blue Cross versus Naus case, a party was precluded from seeking reversal of a judgment on appeal by failing to challenge the arbitration award. So you need to be cognizant to challenge the rulings that you're getting at all levels, be it at the arbitration level or at the trial court level.
And I'll just make a quick plug that Jerry and another partner at our firm, Judy Posner, authored a great article on appeals arising out of arbitration awards. And it's available, I think it's through the Advocate magazine, but I do believe it's available publicly. And if you're interested, you can reach out and we can send you a link. But we all know it's a difficult and uphill battle you find yourself in if you're in such an appeal, but this article does a fantastic job of identifying the helpful cases that I think not everybody is aware of.
Thanks for the plug.
Yeah, of course. So evidentiary issues. A challenge to the erroneous admission of evidence requires a timely, specific, and proper objection or a motion to exclude or strike the evidence. That one I think we all know well. But the challenge to an erroneous exclusion of evidence requires an offer of proof, which needs to include the substance, purpose, and relevance of the excluded evidence. And this can be a common mistake that we see. A trial attorney often has argued very admirably, whether on an opposition to a motion in limine or in response to an objection, that evidence should be admitted because it's relevant to a claim or a defense, and they make a lot of good points. But they fail to make an adequate offer of proof. And a failure to make an adequate offer of proof forfeits any error on appeal. So to be valid, an offer of proof must state the specific evidence to be introduced to prove the existence or non-existence of a fact and issue. The offer must not simply state the facts counsel seeks to prove, because obviously facts are not evidence. There's a case called Semch versus Henry Mayo Newhall Memorial Hospital that's also cited in your materials. And there, a defendant in a medical malpractice case challenged a damage award on appeal because the defendant argued that the trial court erroneously excluded testimony regarding the plaintiff's ability to obtain and secure future employment following her injury. At trial, the defense counsel identified the witnesses he sought to question on this issue and the purpose of their testimony. He said, and I'm kind of paraphrasing just a bit here, but he said, "I will make an offer of proof at this time that I will expect to prove, if not through the testimony of the plaintiff, through the testimony of the supervisor that evaluated the plaintiff at her subsequent employment that she was fired from that job for this reason. The trial court ultimately excluded the testimony, which the defendant argued on appeal would have impacted the damages awarded by the jury. And the Court of Appeal held that the counsel's offer of proof lacked specificity because it did not give the precise testimony to be offered by each specific witness, which would prove the reason that the plaintiff was fired from her subsequent employment. And the proffer only provided conclusory statement that their testimony would prove that she was fired for a certain reason. This is definitely something to be aware of when you're arguing that as evidence should be admitted. To preserve the error in the exclusion of evidence, you must describe the specific evidence, and you have to explain the purpose of the specific evidence and explain its relevance. Having a checklist when you're making your proffers or when you're preparing your oppositions to motions in limine is going to prove crucial in a situation like this.
So one of the very common areas where you'll find preservation of appellate error is going to arise with motions in limine. A proper motion in limine to exclude evidence preserves an appellate challenge when, number one, a specific legal ground for exclusion is advanced and raised on appeal. Number two, the motion is directed to a particular identifiable body of evidence. And number three, the motion is made at a time before or during trial when the trial judge can determine evidentiary questions in its appropriate context. If the trial court denies the motion to preserve an appellate challenge, objection should be made again when the evidence is actually offered. And this is just perhaps a belt and suspenders approach, but it assures that you preserve your appellate rights. As mentioned previously, where a motion in limine is denied, renewal is the better practice where there are changed circumstances or substantially different evidence is offered in the trial, where the motion in limine ruling was tentative or conditional, where the evidence was not specifically identified in the motion in limine, or where there is a changed factual context between the pretrial motion and the trial.
And we see so many appeals relating to motions in limine that you'd be wise as you gear up for trial to just refresh your recollection of what you need to, preserve appeal on the, introduction or exclusion of evidence. It unfortunately is not something that comes second nature for a lot of us, including myself. And so just, taking an hour before trial starts to remind yourself what you need to present in order to preserve appeal. Because as we know, a lot of trials live and die by a motion in limine. So now we have jury instructions. Under Code of Civil Procedure, Section 647, a party is actually automatically deemed to have objected to the giving, refusing, or modifying of a jury instruction. But this is not an automatic, strike that, sorry. The automatic objection can be a trap because it's limited in scope. It only applies to instructions that contain an incorrect statement of law. So trial counsel will be wise to make a clear record regarding the objections to jury instructions, whether by a pocket brief or explicitly stating it on the record. A couple of examples. This is another tricky situation that you should refresh your memory on before commencing trial. First, an appellant cannot assert error based on the trial court's failure to give a particular instruction if the appellant themselves did not request it. So if you believe that a jury instruction is the correct statement of law, but you assert that it's too general or it's incomplete, you must request a clarifying instruction in order to preserve that argument for appeal. And likewise, the trial court can refuse to give a legally correct instruction if the language of the requested instruction is either argumentative or slanted. Parties, of course, have a right to have the jury instruction instructed on the law applicable to all theories of their case, but that right is limited to non-argumentative instructions. And I know we all tend to try to slip in arguments here or there, but you'd be wise to keep it straight to the law when you prepare your special instructions. If a record does not identify the party requesting the instruction, the appellate court will presume that the appellant themselves requested the instruction and thus forfeited a claim of error on appeal. And similarly, if the record does not indicate that the trial court refused an instruction, the appellate court will presume the complaining party withdrew it. You may recall this happened in the Philip Morris case that I discussed previously, in which there was no record of the jury instruction conference or the instructions that were given or refused by the court. So the appellate court presumed that the requesting party withdrew it or that they omitted it from the final requested instructions. Jerry, I think you might have an interesting story to share with us firsthand.
All of us have our own war stories, and today you're subjected to mine.
Yeah.
But I do want to just mention that the rule that Aaron has identified, that jury instructions are deemed objected to, is a state court rule. And you may find that that rule is not applicable in other jurisdictions. And I just wanted to go on and mention one of the matters that our firm handled, and where we successfully argued that the appellant had forfeited its appellate challenge to a jury instruction because the record did not include any indication as to which party requested the instruction being challenged on appeal. And as the Court of Appeal opinion explained, to the extent that appellant's argument is couched in terms of instructional error, the arguments have been waived. It is well established that when the record does not indicate who requested the challenged instructions, or that they were given by the court sua sponte, the appellant is presumed to have requested the instructions, and the doctrine of invited error precludes an appellant's claim the instructions were erroneous. That rule applies here. Although in its brief, appellant states the instructions on the measure of damages were given at respondent's request and over appellant's objection, there is nothing in the record confirming that assertion. The proceedings in which the jury instructions were decided upon were unreported. The appellant's appendix contains copies of the jury instructions given, but there's no indication on the written instructions as to which party requested the instructions, and there were no copies of instructions that were requested and refused. So the upshot of this is document everything and clearly have a court reporter present who can pick up, the cues as to who was objecting to which instructions, because as Aaron has so clearly mentioned, if it ain't in the record, it doesn't exist. And you could so easily lose something where you've correctly argued it, but you can't establish it on appeal.
Yeah, absolutely. And I can't emphasize enough coming armed with a 3-paragraph pocket brief, because you're going to know right before trial starts what the hot topic jury instructions you might be fighting over is gonna take you a long way, because of course we all get swept up in everything going, all the moving parts of trial, that it's so helpful to have those very brief little pocket briefs ready to go before you show up for your first day.
Special verdicts are also a ripe area where you're going to need to preserve your appellate challenges. Failure to object to a verdict before the discharge of a jury and to request clarification or further deliberations precludes a party from later questioning the validity of the verdict if the alleged defect was apparent at the time the verdict was rendered and could have been corrected. Objections to the verdict form generally must be asserted before the jury is discharged. Thus, for example, to preserve for appeal a challenge to separate components of a damage award, a special verdict form must segregate the damage elements, and it must be requested. Otherwise, the appellate court has no way of determining what portion of the award was attributable to the particular category of damages challenged on appeal.
And I actually had my own brush with the possibility of forfeiting an objection to a special verdict. Well, I'll share my own war story. I was a second chairing a jury trial out in Riverside several years ago. And I was on a team representing a plaintiff in a whistleblower retaliation case. And The jury came back and announced a verdict in favor of the defense, in favor of the other side in this situation. But during the polling of the jury, it became clear that 8 jurors had voted in favor of us, the plaintiff, and 4 jurors had voted in favor of the defendant. And as we know, in order to render a verdict in a civil trial in California, 3/4 of the votes, or in this situation, 9 jurors must agree on the verdict. And so it wasn't a verdict in favor of the plaintiff. It wasn't a verdict in favor of the defendant. But our judge, who I believe to be a capable judge, was brand new to the civil trial bench and had come from the criminal world. So this was his very first civil trial ever. And I guess we were the guinea pigs, because after polling, and to us, it became clear that there was not a proper verdict, he started his speech to discharge the jury, thanking them for their service. And he was getting ready to enter judgment in favor of the defendant. And I will say, I was a junior attorney at the time, and certainly, when you're before a judge that seems to be quite confident about what he's doing, you start thinking, am I the crazy one? I'm so confused about why he's getting ready to discharge the jury. And thankfully, my supervisor at the time had the courage and knowledge to stand up and interrupt the judge and object and ask him to send the jury back to continue deliberating, because it was a terrifying moment. I will say it's almost one of those moments you can't prepare for, because you don't think something like that would ever happen. And again, I would be lying if I would say even my very, very senior supervising attorney did not second guess whether he too was crazy and thinking that this was not a proper verdict. But this is just sort of an example to give you those difficult moments where you have to be ready to correct a judge, even when they believe they're correct on the law. I mean, the judge thankfully understood. He did review some authorities before he agreed with us. We kind of, even our opponent was sort of agreeing with us, although she didn't want to totally concede that she agreed with us. But he ultimately sent the jury back. But had we not interrupted to the discharging of the jury, we could have possibly forfeited the objection for an appeal, where at least on the merits we should have won. But we needed that extra piece of objecting to it. So one of the scariest moments, but it ended up an okay situation. So now, following a bench trial, the court explains in a statement of decision the factual and legal bases for its determination of the issues at trial. And this concept is set forth in Civil Code, or Code of Civil Procedure, Section 632, as well as the California Rules of Court, Rule 3.1590. So perhaps the most important aspect of a statement of decision is that it enables the party to avoid the doctrine of implied findings. So if a party fails to request a statement of decision and then appeals from the judgment, the appellate court presumes that the trial court made all factual findings necessary to support the judgment, as long as there's substantial evidence in the record to support the judgment. And for those of you who are familiar with the appellate practice, you know that the substantial evidence standard is the highest bar to overcome in a civil appeal. So you don't want to find yourself in a situation like that. There's a few key procedural requirements that you should be mindful of when it comes to statements of decision. And first, the party requesting a statement of decision must do so in a timely manner. And that's going to be under Code of Civil Procedure, Section 632. The failure to make a timely request for a statement of decision forfeits a party's right to a statement of decision. And as I just discussed, there can be some real consequences to not obtaining a statement of decision. The applicable time frame for making a request for a statement of decision turns on the length of the trial, but generally speaking, it should be made within 10 days after the court announces its tentative decision. And second, a request for a statement of decision may be oral or written, although we always recommend it be in writing or before a court reporter. But the request itself, it must specify the issues to be addressed by the trial court. And the issues to be addressed by the trial court are the facts and the issues that are essential to the elements of your claim or your defense. And third, if the court's proposed statement of decision fails to address the particular issues identified in your request for a statement of decision, or you believe it's ambiguous, you must file timely objections to preserve error for appeal. The objections must contain enough detail to allow the trial court to correct the defect, and a failure to object constitutes a forfeiture, and it allows the appellate court, again, to imply findings in favor of the judgment. And that's not a situation you want to find yourself in.
So in the category of shameless plugs, then I'll also mention that Judy Bosner and I wrote an article addressing statements of decision, how to preserve appellate challenges through objections there. So I would commend that to readers as well.
Absolutely, and I believe that's also in the Advocate. So
Awesome.
easy to Google, but feel free to reach out to us if you'd like a link.
Um, one last category of specific context where objection is required with regard to post-trial motions. Generally, post-trial motions are not required, and you don't need to file them in order to preserve appellate issues. But there are three notable exceptions to this general rule. And a post-trial motion is necessary to preserve the error for appeal under the following circumstances. Number one, where you're going to be arguing on appeal that the damages awarded were excessive or inadequate. And just by way of mention, this is going to be true both whether there was a bench trial or a jury trial. You can't just assume, well, why am I raising objection and bringing it to the judge who ruled against me? But you need to do that, identify your arguments, and preserve your issues. Additionally, to preserve claims of jury misconduct and newly discovered evidence, you need to raise those claims through a new trial motion. And again, perhaps it's obvious when you think about it, if you don't bring this up through a new trial, these sorts of issues up through a new trial motion, there's going to be absolutely no evidence of what occurred. If the misconduct occurred in a jury room, so for example, a jury were to get information that didn't come through the trial, they did their own research through Google. If that's not brought out through a new trial motion with declarations and the like, there's no way for an appellate court to review it. And that would also be true for newly discovered evidence. And sort of the last thing is this wouldn't be California if there weren't exceptions to the forfeiture rule. And so, Aaron, do you want to address
Yeah,
some first?
of course, I'll handle the first few. So, pure issues of law applied to undisputed facts. So, appellate courts have the discretion to address for the first time on appeal pure questions of law applied to undisputed facts. Now, courts are more inclined to consider these kinds of issues when there's little to no prejudice to the responding party. So, in the event you find yourself preparing an appeal where you want to raise issues like this, and I will be honest, this comes up quite a bit. I think a lot of times when either you or an appellate attorney is preparing your appeal, you may recognize issues that could have been raised below. They're pure issues of law, and that they could bolster your argument or they could win the day. You should be wise to include an explanation for why there was no prejudice caused to the other party by you raising it for the first time on appeal. There's also new legal authority reflecting a departure from prior law. An appellant can raise a new unpreserved theory on appeal when it rests on recent authority that was issued after the trial court's ruling, only when it could not have reasonably been anticipated by trial counsel. When it comes to new legal authority relating to the admission or exclusion of evidence, for instance, the change in law must have been so unforeseeable that it was unreasonable to expect trial counsel to have anticipated the change. And frankly, this may become a high bar to surpass. So you should be mindful that you will need to make a showing that the change in the law could not have reasonably been anticipated during the trial. There's also a lack of subject matter jurisdiction, a favorite subject we all have from our first year civil procedure classes. A challenge to a trial court subject matter jurisdiction is never forfeited. This challenge can be raised at any time, directly or collaterally, even for the first time in a rehearing petition or a petition for review to the Supreme Court. Once it's raised, the appellate court must address the jurisdictional issue. So at least theoretically, it's not up to the discretion of the appellate court to consider an issue of subject matter jurisdiction, even if you raise it for the first time on appeal.
And just by way of mention, the absence of subject matter jurisdiction can be raised at any time. And that it can be raised in a petition for rehearing before the Court of Appeal. Obviously, it can be raised in the briefs, but in a petition for rehearing, it can be raised in terms of a petition for review. Because if there's no subject matter jurisdiction, the court shouldn't be issuing a determination, an opinion.
Right.
And the same is going to be true for lack of standing. So if there is a claim that a party didn't sustain damages, for example, or wasn't a party in the proceedings below and has effectively no stake in the game, a lack of standing argument can be raised. Interestingly enough, California has a whole host of matters, statutory exceptions to the standing requirements, or excuse me, the preservation of issue requirements. In section 647, which Aaron and I have drawn reference to sort of during the course of these discussions, you do not have to object, for example, to the judgment. You don't have to object to jury instructions requested by the opposing party or the refusal of a court to give jury instructions. A ruling sustaining or overruling objections to evidence, these matters are all preserved for appellate review pursuant to section 647. And finally, an insufficiency of the evidence claim does not need to be specifically preserved. If the judgment isn't supported, then the Court of Appeal will hear it and consider the evidence. But of course, remember that all the evidence will be construed in favor of the party prevailed in the trial court below.
Absolutely. So at this point, I think we will take a look at if any questions have come in. And there are none, which is amazing. It seems like we're just doing such a fantastic job answering the questions. So I think when it comes to, preparing for trial, one of the most obvious and important pieces of advice as appellate attorneys we can give you is to show up well prepared. Because, I'm no super seasoned trial attorney myself, but I do know that with the lack of sleep that you're going through, the number of issues, the jury management, the witness management, everything that you're going through, that sometimes some of these very minor issues that your case could hinge on are sort of your last priority. So getting these things sorted before trial starts is an incredibly important factor. I do see we have another question. How about appealing a demurrer sustained without leave to amend?
Well, that will be, you don't need to object to that. That will be deemed objected to. And very fortunately, it's one of the few areas where you can articulate new theories on appeal, even if you're relying on a theory that wasn't relied on by trial counsel in the complaint itself. So it's a de novo review, and the Court of Appeal will take all inferences from the complaint to see whether a possible theory can be raised that will substantiate a complaint and enable the plaintiff to move forward.
Jerry, do you have any experience with prevailing in a situation like that? Any tips on arguments that should be raised?
We've actually done that successfully in a couple of different matters, and some quite recently where we've come up with different alternative theories that weren't considered below, that the Court of Appeal considered and said, yep, this would create a viable complaint. And it certainly came as a surprise to both our own trial counsel and opposing counsel that the standard of review is very, very different than it would be in all other contexts where you can address new theories.
Mm-hmm. And just generally for Leah's question about appealing a demur, I think this raises an important. A lot of our conversation today has been focused on issues that may come up in trial. But when it comes to briefing, say you're on a motion for summary judgment, those are also situations where you can forfeit an argument for appeal. So I think we've touched on it very briefly, but you are required to develop your arguments on appeal. I think a lot of, or to preserve the issue for appeal. I think sometimes we do get, a trial counsel who present us with situations where they're absolutely right in their concern or their argument or their objection, but we have to do a lot of massaging to try to convince the Court of Appeal that they properly developed it before before the trial court and that it was properly preserved. So, really fleshing out your briefing is, I mean, it's going to only help down the road. I see another question that's, do either of you have anything further to add to the exception, no waiver if purely a question of law? For one thing, if the issue is not raised in a response to a tentative statement of decision. The issue is not raised in a response to a tentative statement of decision. I mean, like I said, considering a pure question of law is a discretionary action by the Court of Appeal. But they are entitled to do it even if it wasn't raised below. I can't think of a specific situation in this moment, but I would believe this still applies if you fail to raise it in response to a tentative statement of decision. Jerry, what do you think?
No, I agree. And I also wanted to point out that as a respondent, you can raise additional arguments
Right.
by which you show that the judgment from the trial court should be affirmed. So supposing the appellant raises good arguments that ultimately hold sway with the Court of Appeal, you can still have the judgment affirmed in your favor by raising new legal arguments that show that as a matter of law, judgment should have been rendered as it was. And this arises under Code of Civil Procedure Section 906, which allows the respondent to raise new arguments on appeal in support of the judgment, even though the respondent does not appeal the decision itself. So there's an appellate trick for you.
Absolutely. Yes. I think when it comes to being the respondent on an appeal, you have a lot more leeway about the types of arguments you can make, frankly, because even on a de novo review, there's generally a presumption in favor of correctness by the trial court. Obviously, when you're an appellant, that can be quite frustrating because when you think of de novo review, you think this needs to be looked at with fresh eyes and an independent perspective. But you're absolutely right. The Court of Appeal, and certainly I think in some situations, surprisingly, can glom onto arguments that you thought that wasn't even raised in the trial court and it was barely raised by the respondent. But there is, you have the statistic, Jerry, of how often respondents are prevail on appeal?
Typically, after a trial, respondents prevail about 80% of the time in state court. And if with regard to appeals from pretrial type motions like summary judgments, demurs, those sorts of things, it's slightly more, probably between 20-25%. But I do want to point out, although the litigants are accorded the ability to raise new legal arguments on appeal,
Yeah.
the Court of Appeal itself cannot rely upon a legal argument that hasn't been addressed in the briefs. And so that if the Court of Appeal relies on an argument that neither party or that the parties have not addressed, then that's a mandatory rehearing petition. And the court will have to take briefing on as to whether the court was right in terms of its analysis.
Mm-hmm. So in your years of practice, and for those attending, Jerry has been an appellate attorney for his entire career, all of 5 or 6 years you've been practicing?
It's slightly north of that, but still.
Oh, got it. Okay. I'd be curious if you could share with the group, particularly at trial, what would you say some common mistakes. I know we've talked about a lot of them, but I'd be interested in hearing some so our audience can be aware of them as they enter trial.
Well, thanks for putting me on the spot. But look, in terms of common mistakes, I suppose it's just absence of preparation, getting your witnesses lined up, making sure that procedurally you have evidentiary support for all of the elements of whatever cause of action you're seeking to prove. Because you have to be prepared on appeal to show substantial evidence for each of the various elements of the various causes of action. And it's just incumbent upon you to make sure that you've gone through everything and you've got a checklist to show that you've set out everything you need to, because there are no do-overs. Once a witness has been dismissed, you're not likely to be thinking about bringing him or her back to pick up that one piece of information that you forgot to address. And so for me, I think that's probably the biggest thing I'd say.
Yeah.
Preparation, obviously we're dealing with a very difficult topic here, because it's very easy to say, challenge everything and make sure you preserve all the issues. But as you and I were talking about just before the seminar began, you're sort of balancing a lot of different factors. If you're always objecting before a jury, the jury may get annoyed with you, and that won't play out well for your client. On the other hand, if you're trying to preserve all potential error, then appellate counsel will be upset that you failed to preserve the issue. You don't want to slow down the momentum of the trial. You don't want to slow down the favorable testimony you're eliciting from the opposing party's witnesses. And yet you need to sort of be cognizant of so many things. And that's why I chose to become an appellate attorney, because it's easy for me to say in hindsight, well, you sure blew that, but I'm not going to be, put to task, because I'm sure that I would do no better and undoubtedly far worse than any trial lawyer who's watching this presentation.
Well, I don't know about that, but there is a reason I transitioned from trials to appeals. I will say that much. But I am no ethics attorney in the least. I think I got an A- in legal ethics in law school, which I felt was a very adequate representation of my knowledge of the rules of ethics, rules of professional conduct. But and we didn't touch on this, and it's an entirely separate seminar. But of course, all of these issues implicate your ethical responsibilities, right? And so being prepared and preserving error is crucial for competently representing your client and preserving anything that might go wrong at trial. I have another question for the statement of decision wizard on the panel with me. I don't know if we have an answer for this one. I think maybe the answer is obvious, but do you have to get a statement of decision if there is no trial and it's just a judgment resulting from a petition to confirm arbitration award?
I don't recall a statement of decision being applicable in that situation, because it seems as though it's a motion that's going before the trial court, where the trial court's not going to be taking on evidence. It's just going to be ruling on whether the arbitration award should be vacated or confirmed. So I don't recall a context within which a statement of decision is going to be called for.
I can't say with certainty but that's my feeling as well, Jerry, because I think this might be why you need to preserve error by both presenting it before the arbitrator, and the arbitrator will inevitably present findings of fact and of law, and then you also must present it before the trial court for it to be confirmed or corrected or vacated. But if feel free to send us an email on that one, because I don't want to mislead anyone if we find out there's some exception that we don't know about. But
no.
so
Well,
I think
I was just going to thank everybody for joining us today, and thanks for giving us the opportunity to present topics with which we deal with every day. So Appreciate your participating.
Absolutely.